Hi, I'm the Strenuous Objector, lawyer and overthinker of pop culture, and I'm here to take a look at your favorite movies and TV shows and ask the question, is that legal? Today, I'm going to look at the case of the state versus Kevin McCalister. Now, for the two of you out there who have never seen Home Alone, it's the story of irresponsible parents who leave their 8-year-old son Kevin home alone during Christmas.
Mom? Dad? Where are you guys?
Something that's probably illegal as well, but that's a question for another time. While the parents are away, the wet bandits are out robbing this rich neighborhood blind and flooding the houses, which to me is just overkill. When they finally get to Kevin's house, though, he's got some traps set up to protect his home. And that brings us to the question for today. Is it legal to use traps to protect your home? Now, the McCallisters live in Chicago, so we'll be looking at Illinois statutes and cases for this discussion. So keep that in mind. Also keep in mind, this is not a review of the movie. I'm just deciding if what he did was legal. That's it. With all that said and done, let's take a detour to Iowa. Katko versus Briney is a 1971 case from the Iowa Supreme Court. To the normal public, that name probably doesn't mean a thing. But for law students, it'll set off all kinds of red flags and alerts, because it is usually considered the premier case when discussing if a homeowner can set up traps in their home or even abandon buildings on their property. Now in that case, Briney was a homeowner, and he was fed up with people sneaking into his old farmhouse and stealing stuff. See, he owned the land, but he didn't actually live in the building. So how fed up was he? Enough that he decided to set up a spring-loaded trap. Specifically, a 20-gauge shotgun right in front of the door to decimate any would-be thieves. And, surprise, surprise, someone did break in. Katko. He opened the door and was shot straight in the legs, and as you can imagine, it was pretty bad. Katko sued Briney for his injuries, and the court said that it is the accepted rule that there is no privilege to use any force calculated to cause death or serious bodily injury to repel the threat to land or chattels, unless there is also such a threat to the defendant's personal safety as to justify self-defense. Remember that self-defense aspect for later. Now, clearly there's a difference between an unoccupied farmhouse and a family home with a child inside, right? Well, one Illinois statute deals with this kind of situation. Kind of. See, Chapter 720 of the Illinois Compiled Statutes Annotated, Article 12-5.1, is labeled Criminal Housing Management, and it says that a person commits criminal housing management when, having control of residential real estate, he or she recklessly permits the physical condition of the residential real estate to become or remain in any condition which endangers the health or safety of a person other than the defendant. Now, what that all really means is that if you own or control property, it's criminal to recklessly let its physical condition degrade, or in the case of traps, become unsafe for others. How can we include traps in all that legalese? Well, in People v. Swartwout, the Illinois 2nd District Court of Appeals held that traps fall under unsafe physical conditions. See, Swartwout set some traps up in his home to injure any health inspectors sent to his property. What kind of traps, you ask? Well, the usual rat traps. Oh, and chainsaw traps. They said that the key element is that the condition of the home and the basic nature of this offense remains unchanged, whether the property was unsafe because defendant had set rat traps, had allowed debris to accumulate, had failed to repair fire damage, or as a result of a combination of factors. So the court put rat traps right up there with failing to repair fire damage. The biggest concern for the court, though, was that even if he had specific people in mind for his traps, traps are mechanical by nature, and like honey badgers, they don't give a shit. Anyone, kids, police officers, or even your own family, could accidentally set off one of those traps and get injured. That is what makes the action reckless and criminal. Now that's obviously a very specific statute, and Kevin might not even be considered an owner or manager of the home for that statute to apply. But could Kevin get in trouble under another Illinois statute? Well, Chapter 720, 9-3 states that you commit an aggravated battery when, in committing a battery other than by the discharge of a firearm, he or she knowingly does any of the following: causes great bodily harm or permanent disability or disfigurement. Now that certainly seems to fit here. The traps are definitely intentional actions by Kevin. Kevin deliberately ices the stairs, sets up an iron in order to fall on whoever pulls the light string, puts a heating loop on the doorknob, and sets up the blowtorch trap at the back door. Hell, Kevin shoots both of them with a BB gun.
The little fella now and open the door.
Hello.
Now, some of the other traps, like the feathers, don't fit here because, well, they wouldn't cause great bodily harm. But others definitely could. I'm looking at you, Blowtorch. Saying all of that, remember how self-defense was mentioned earlier? Yeah, well, that's where we get down to the real argument. See, Illinois has two statutes that fit here. Chapter 720, 7-1, Use of Force in Defense of Person, and Chapter 720, 7-2, Use of Force in Defense of Dwelling. Let's look at them both one at a time. For defense of a person, it says that a person is justified in the use of force against another when and to the extent that he reasonably believes that such conduct is necessary to defend himself or another against such other's imminent use of unlawful force. That kind of sounds like it fits here. Kevin was protecting himself. The wet bandits certainly acted like they wanted to hurt Kevin.
I'm gonna kill that kid!
But there's a little caveat. In order to use deadly force, or the type that could cause great bodily harm, like many of Kevin's traps, you have to reasonably believe that there's an imminent threat of death or great bodily harm. That would make sense later on when they're threatening to kill him. But remember, he overheard the wet bandits talking earlier in the day about committing the burglary at 9 p.m. that night. After Kevin came back from the church, he set up the traps that could easily cause great bodily harm or even death, all well before there was even close to an imminent threat. But what about use of force in defense of dwelling? Well, that statute says that you can only use force that could cause death or great bodily harm if for two reasons. And one of them says he reasonably believes that such force is necessary to prevent the commission of a felony in the dwelling. Well, guess what? Burglary is a felony. And home invasion, too. See, Kevin tried his hardest to kill these two idiots. But what's going to keep him out of juvie is if he reasonably believed force was necessary to prevent a felony. When Kevin overheard the wet bandits talking about breaking into his house, at that point he knew they were planning to commit a felony. Now, that actually sounds like Kevin, though definitely reckless, may actually in a very technical sense be justified in hurting Marv and Harry. But before you race home and duct tape a blowtorch above your back door because you're scared Joe Pesci and Daniel Stern are going to sneak into your house and steal all your stuff and flood it, remember that if an officer had come back to the house and gotten a severe burn from the hot doorknob, or Kevin's family had come home early and got hit with a blowtorch, Kevin would not have protection under the law. An accidental injury may be covered if he had shot someone in defense and accidentally hit someone else. But remember, we're talking about that spring-loaded trap concept. His recklessness would have definitely overridden his original intent when it came to accidental victims. He'd be spending his next many birthdays in juvie, pumping iron and wishing he could order pizza and scare the delivery man. But wait, what if Marv and Harry sued the McCalisters for their injuries? The defense of dwelling statute says the aggressor can't sue for damages unless the defender's use of force involves willful or wanton misconduct. And Swartwout just determined that putting up traps was reckless. We don't know if in Illinois Kevin's use of traps that could cause great bodily harm or death was willful or wanton misconduct. But that does bring us back to Katko. Because remember, it's a civil case. And even though it's an Iowa one, the jury found that Briney, the homeowner's conduct, was wanton. And he too was protecting his property. So take it as you will. In the end though, after reviewing all the facts and the law, I find that in the case of the state versus Kevin McCalister, what Kevin did, while illegal, was most likely justified, at least under Illinois law, and at least in relation to the wet bandits. But Harry and Marv have a decent case against the McCalisters for any injuries they got from all of Kevin's saw-like traps. With that all said and done, I'm the strenuous objector, and court is adjourned. Now if you liked the video and want to see more, hit subscribe, or head to the comments and let me know what movie or TV show you want me to take a look at next. All case and statute citations are in the description. Also, all the information in the video is for educational and entertainment purposes only, and should not be taken as actual legal advice. If you have a legal question or problem, please contact an attorney near you.